As Dean, and for those of you I haven't met, I'm Lawrence Austin, Dean of Osgoode. It's always a pleasure to come to the Genest Lectures and do a short introduction not only of the speaker, and we are incredibly grateful to have Professor Fiona de Londras here with us, and I'll say more about her in a moment, but also of this series and what's made these visits possible in the extraordinary gift given to honor Pierre Genest by those who knew him best, and the Genest Memorial Fund, which I was just checking to see what year we're at, but it was established in 1989, which means we're now into the second quarter century of the benefits of that here in 2015. Pierre Genest, no matter how many years pass since he was in active practice, continues to loom so large and in so many positive ways over the legal community. And not only was he an incredibly well-known advisor and counsel to many different clients, and of course a star graduate of Osgoode from the class of 1954, but also someone who, through his personal qualities, his commitment to Canada, to bilingualism, to multiculturalism, really has come to define, I think, the best traditions of the legal community. And the fact that this gift has gone to make it possible to bring visitors who are focusing on global issues, as the talk today will wonderfully demonstrate and amplify, and the fact that this perspective of seeing Canada's place in the world, seeing the global events and dynamics that shape law more generally, is again testament to the kind of intellectual curiosity, reach, and impact of Pierre Genest. And it's a huge pleasure to have Kate Genest here with us as a family representative, who herself is following in the family business and is a lawyer practicing with Miller Thompson now here in Toronto. You know, I'm glad I'm not her, because the weight on her shoulders of what's going to be expected can't be insignificant, and it's of course a wonderful relationship Osgoode has had with the Genest family that we are very proud of. So thank you for being here, and thanks everyone for joining us. The topic today couldn't be more relevant, of course, always in both intellectual and very personally felt ways, especially on this day. The topic is counterterrorism, transnationalism, and human rights. And Professor Fiona de Londras, who, as I mentioned, is not just here for the lecture, but here is our Genest visitor, and so we'll be doing visits to classes, meeting with students, and I'm grateful coming to my ethical lawyering class next week. Wears a number of institutional hats, and I learned this because when I found out she was going to come, I just wanted to get a taste of what we were in for. So I did as what most students would do these days. I went to YouTube so I could see her in action, and there are a number of talks she's given recently and podcasts and many other media available, but each time she was introduced, she was given a different institutional affiliation. So I knew that she is someone who is able to divide loyalties. And so I'll mention a few of those, but of course now her being part of the Osgoode extended family is what she will be most known for, at least in these crisp confines today. So she's a professor at Durham University, a wonderful law school, of course, in the UK, and has been a co-director of Durham's Human Rights Center over the period 2012 to 2014. Before that, she was a rock star in the academic legal community in Ireland, where she keeps many affiliations. She is also currently a visiting professor at the much warmer University of New South Wales, home of the Gilbert and Tobin Centre for Public Law, known to many around this room, and UCD, University College in Dublin. And she is also very active on the advisory boards and with a range of other public law and constitutional centers in Europe that, excuse me, I won't rehearse too much or I'll lose my voice. But I wanted to say a word about her scholarship as well. And again, having done this appetizers through YouTube, I've been just so impressed at the range, both on international and transnational law, the field of rights, criminal justice, terror and anti-terror, and also, of course, law and gender, law and society, the impact of law on lived experiences. And any one of those could occupy a scholar, and of course occupies many scholars in their full-time pursuits. But Fiona's ability to master and bring together insights from those related but distinct disciplines is really remarkable, and contributes again to her being in such demand, her being such a prolific author of dozens of books and articles, and of course very active in bringing together collections, editing collections, hosting, and bringing scholarly conversations and debates to life, which is, we hope, what she is here at Osgoode to do. So again, she's also shared this year as a visitor in 2014-15 with Oxford, where she's a fellow at the Oxford Human Rights Hub. And that's a name we haven't used very often for things here, so note to file, we may have hubs coming. But she is also an associate of their Human Rights for Future Generations program, and again, a number of other institutional roles that she may touch on. So with all that, with our gratitude to the Genest family and to the fund, with our gratitude to Fiona, and with the need to keep the home fires burning warmly today while we expand our reach to events happening around the world, please join me in welcoming Fiona de Londras to Osgoode and to the Genest series.
Thanks very much, Lauren. I think I might have to change my Twitter handle to flaky legal rock star with divided loyalties. I quite like that. So good afternoon, everybody, and I would like to start by thanking Osgoode, the Genest family and the Memorial Fund for welcoming me here for these 2 weeks that I'll spend. The last time I visited Osgoode, it was March, and I thought, March, January, no big difference. Weather-wise, well, I'm surviving, and no, it's wonderful to be here, and I look forward to all of the events that I'll take part in over the next few weeks. And I want, as I start, to particularly thank Jodie Ann for all of her work in sorting out the logistics of my visit. I may be flaky, but I hope I'm not demanding. But nevertheless, she has answered everything I've asked for extremely well and graciously. What I would like to do today, over around 40 minutes or thereabouts, is to explore the relationship between transnationalism, counterterrorism, and human rights across a number of dimensions. And I don't want to suggest that the exploration or the picture that I'm going to present is a comprehensive one. In fact, the transnational nature of counterterrorism is probably matched only by, in its scale, only by the scale and nature of counterterrorism itself, which I'll come on to in a second. So rather than try to be utterly comprehensive, which would take a lot more time than any of us have today, I want to pick up and explore transnationalism and counterterrorism across three distinct themes or fields. The first one relates to transnational lawmaking. The second one relates to the use of transnational routes or procedures to try to adjust or recalibrate pre-existing legal standards. And the third relates to the transnationalism of what I'll call the business of counterterrorism. In other words, the everyday actual activity of designing and executing counterterrorist operations, investigations, and so on. And having looked at these three trends in relatively broad terms, I want to suggest that even though transnationalism in counterterrorism is sensible in many ways, it's perhaps even demanded by the nature of globalization and contemporary terrorism, there is also something for constitutionalists to worry about in transnational counterterrorism, something that emanates from some distinctive features of transnationalism and therefore is added to or a little bit different to anxieties we might have about constitutionalism and counterterrorism at the domestic level. And I then, having outlined some of these constitutionalist concerns, want to try to finish on an optimistic note. It's always a bit tricky. I might run out of time before optimism. No, I'll try not to. To suggest that even if transnational counterterrorism offers or throws up some particularly anxious questions for us, that does not mean that there is not the potential or capacity for an imaginative and appropriate response to that from those of us who believe that we want to emerge from this so-called age of counterterrorism with constitutionalist values of human rights and limited power intact, or at least not utterly ruptured by what has happened since 2001. Rather than try to present any kind of concrete model, I don't suggest that in 40 minutes we can build a model of transnational constitutionalism. Instead, I want to just suggest 4 principles that might inform, or commitments that might inform, our responses to the particular challenges of transnational counterterrorism. Now, before I go on to look at transnationalism in this context across the 3 terrains that I've outlined, it is helpful, I think, to just spend a couple of minutes wondering what counterterrorism is. It is, de rigueur at this stage to start every lecture on terrorism by saying, well, really, terrorism is whatever somebody with power and capacity to define it says it is. And that, of course, feels particularly so today, given the very immediate response to the attacks in Paris. But even if we accept and if we acknowledge that terrorism is something that is difficult to define, and that perhaps we don't want to spend an awful lot of time today thinking about, it is important to grapple a little bit with what terrorism might be if we are to understand what counterterrorism is. One of the challenges for lawyers in trying to answer the challenges of counterterrorism is that we fixate on law. We see counterterrorism as something that is a body or a set of laws, whereas in fact it is something far broader than that. Counterterrorism is in fact anything that is done to prevent or respond to terrorism, which is in effect, and simply put, any criminal activity intended to terrorize in order to achieve a particular goal. Now, if we think about counterterrorism beyond law, and we think about it in that admittedly frustrating and circular way, simply anything to prevent and respond to this ill-defined phenomenon that we might call terrorism, then the breadth of counterterrorism, which is the breadth of that with which we ought to be concerned, begins to become clear. And so counterterrorism, when seen this way, is not simply about law. It's not simply about military activity or financial regulation or internet governance or counter-radicalization or democratization or building the rule of law or anything like that. It is all of those things and more. Counterterrorism is, in effect, an ecosystem. It is a set of interdependent activities, laws, standards, processes, and operations, all of which should be seen as a whole in order for us to properly grasp the nettle of assessing what challenges counterterrorism holds for us. And so even though the first 2 categories that I have identified are admittedly very lawy, the third category, the business of counterterrorism, goes beyond law to think a little bit more about some practical operations and particularly about engagement with different forms of power beyond the state in order to undertake counterterrorism. So that, I think we can all agree, thankfully short meditation on what counterterrorism might be, brings us then to the first of these realms of transnationalism that I want us to think about. And that is making law, making transnational law. Here I want to talk about 3 particular aspects. The first is Security Council resolutions, and in particular 2 resolutions which have created obligations for member states of the United Nations to themselves create domestic criminal law. In other words, legislative resolutions of the Security Council. I want also to think a little bit about the Counter-Terrorism Committee, which was established by one of those resolutions, and the role that it plays in forming and informing those domestic processes of lawmaking as a form of transnational lawmaking. And I want also to think a little bit about the EU and the EU as a legal actor here. Before I go on to talk a small bit about each of those three things, the sort of highlight point from this section is the importance of thinking about how fundamentally problematic it is for international institutions to effectively make domestic law or to mandate the making of domestic law. Because if we think, and I'll come back to this later, about hallmarks of domestic lawmaking, participation, democracy, transparency, for example, those are frequently absent from these international processes which result in domestic lawmaking, in other words, from these transnational processes of lawmaking. The Security Council is always the easy place to start here because it has done something especially interesting and especially at the time unexpected in relation to the making of law in the context of counterterrorism. As I'm sure most of you know, under Chapter 7 of the UN Charter, the Security Council can promulgate resolutions which are legally binding on all of the member states of the United Nations, rather. And very shortly after the attacks of September 2001, it introduced Resolution 1373. This was a pretty extraordinary resolution, as well as establishing the Counter-Terrorism Committee, which I'll talk about more in a few minutes. It required member states to ensure that certain types of activity were criminalized. Now, it is perhaps difficult for us to really remember this at this remove, but in 2001, actually not that many states would have had dedicated counter-terrorist law. They had criminal law. They didn't necessarily have particularly dedicated law to deal with issues that were considered particular to terrorism. And so by requiring in Resolution 1373, and particularly in Article 1 thereof, that all states shall criminalize the willful provision or collection by any means, directly or indirectly, of funds in their territories with the intention that those funds should be used, or in the knowledge that they are to be used, to carry out terrorist acts, Resolution 1373 created a legal obligation to promulgate domestic criminal law that would in some way comply with the terms of Article 1.1, which you'll have noticed are quite vague. And so there was this need to create domestic law, and that domestic law, where it was created in response to this resolution, has a transnational character. Its provenance or its motivation is an international obligation. Now, forests were felled to talk about how problematic Resolution 1373 was, particularly from the perspective of thinking about the role of international institutions as they relate to domestic institutions. But in spite of this, when the Security Council came at the end of last summer to confront the issue of foreign terrorist fighters, about which states are extremely anxious, a similar approach was taken in Resolution 2178. In other words, a legislative approach. Article 6 of that resolution, which first of all reiterates the 1373 obligation to criminalize financing of terrorism, provided that all states are to ensure that their domestic laws establish serious criminal offences sufficient to provide the ability to prosecute and penalise travelling abroad, facilitating the travel abroad, training people to travel abroad, anything you can imagine relating to going abroad in order to engage in terrorist activities. And so, even countries that have effectively no issue with foreign terrorist fighters were required to promulgate domestic law that would criminalise, through serious criminal offences, all of these activities relating to foreign travel for the purposes of engaging in so-called terrorist activities. And it was a very interesting spectre, for example, to watch the Minister for Justice in Ireland stand up in the Seanad or the Upper House, the Senate, and say, no, senators, we don't really have a problem with foreign terrorist fighters, but we have to pass this law. because the Security Council requires us to do so. So again, in a similar vein to 1373, this resolution creates the imperative towards transnational criminal law. It doesn't, of course, particularly help the states in question to determine what the content of those domestically promulgated laws with a transnational provenance would be, but worry not. The Counter-Terrorism Committee is there to help us with that. So the CTC, also established by 1373, is usually spoken about in the context of asset freezing and listing, in other words, financial sanctions or counter-terrorist financing. And that's one part, a big part, of what the CTC does. But one branch of the CTC, the Counter-Terrorism Executive Directorate, I think it's called, is heavily involved in capacity building around lawmaking. In other words, in helping states to think about and model how they might, or what the content of their laws might be in order to properly confront, or what is considered to be the proper confrontation of a terrorist threat. So you have the creation of model laws, for example. You have knowledge sharing or capacity sharing between representatives of member states at workshops and so on, where you effectively see full-scale borrowing of provisions across states. Kent Roach in U of T has done wonderful work looking at the sort of confluence of provisions across counter-terrorist law in his book, The 9/11 Effect, for example. Now, bodies such as the CTC are involved in processes that result in this. So I don't want to say too much more about that now, except to mention that the role of international entities that are engaged in trying to model laws for national states is also an aspect of transnational lawmaking that we might want to be concerned with. I can look more quickly, for the purposes of time, at the European Union. The EU had no counter-terrorism law, really, on the 11th of September 2001. Criminal justice was and is in many ways a touchy subject for member states. They more or less want the EU to stay out of it. But very soon after the attacks of the 11th of September 2001, the EU put in place a process of creating a roadmap and then an action plan for countering terrorism. And the action plan is periodically updated and revisited. And the scale or the breadth of the activities that the EU thought it might engage itself with in the context of counterterrorism in 2001 seemed pretty extraordinary. However, at this remove, when we look back at what the EU has done since 2001 in counterterrorism, it seems in fact to be the case that it has engaged itself in a hugely wide variety of activities under the umbrella of counterterrorism. Now, some of these activities were engaged in by means of law. And what is significant to remember here, of course, is that the European Union can create laws that are directly effective in member states. In other words, that take direct effect. They can also create laws that require their implementation in domestic states. So even though it's on a regional rather than a global level, this is also a locus for transnational lawmaking in the context of counterterrorism. Now, given that the EU had no counterterrorism law really at all in September 2001, it's extraordinary to recognize that between that time and the middle of the summer of 2013, it promulgated 231 justice and home affairs measures in the context of counterterrorism. I didn't count them myself, I should say, but some members of a team of researchers that I was working with on a project of the EU and counterterrorism did so. So 231 measures in 12 years. That is a very hyperactive rate of lawmaking, particularly for an international institution in which consensus is largely required. Now, not all of those 231 measures were legally binding. 88 of them were. But what is particularly interesting is this column here, which are council conclusions. 111 of those measures were council conclusions. Council conclusions are political agreements. So the council is the prime ministers of all the member states sit around and they create a political agreement of some kind, which then filters down to the institutions of the EU, which have to do something with it. And generally what they do with it is to create all of these other measures, some of which are legally binding and some of which are not. In the context of the EU, it's interesting to see that some patterns people have noticed in domestic lawmaking around counterterrorism are discernible also at the EU level. So it's difficult to say that things happen at great speed at the EU level. You've got an awful lot of member states with an awful lot of agendas. So they don't generally happen at speed. But if you break down the legally binding measures, you see a lot of what I call, or not a lot, I should say a number of what I call capitalizing measures. These are measures where the policy decision was agreed upon before September 2001, or in the other case, before the Madrid and London bombings, but enough political consensus could not be gained to actually translate that into a legal measure. Then a terrorist attack happened, the measure is repackaged as a counterterrorism measure, and hey presto, we have in one case a framework directive, that's for the European arrest warrant, and in the other case a directive itself, which was the data retention directive, now struck down by the Court of Justice of the European Union. So we've seen this in domestic contexts, that sometimes governments will use, or not use, but will take the opportunity presented by the aftermath of a terrorist attack to introduce a measure that they previously struggled to introduce. You see that similar pattern at the EU level. Here, though, of course, creating obligations for all of the member states. So well over 20 member states and hundreds of millions of people. So very significant in this context. In fact, very few of these measures are what we might call terrorism specific. Most of them are terrorism related. In other words, criminal justice measures that have some application to the counter-terrorist context. But nevertheless, well over 200 provisions introduced in 12 years is a very significant level of activity. So that's the first thing then that I wanted to outline. And remember now, stay with me, there is optimism coming. And that is making law on the transnational level. The second that I wanted to talk about is influencing legal standards. Now this is different, similar but different to the first category, because what I'm talking about here are activities undertaken by states in order to try to adjust pre-existing legal standards within international or transnational law. Here or regional law in particular. So here we have this odd paradox in a way of states wanting to engage with law because for them the legal terrain matters. They want a legal terrain on which their desired counter-terrorist activities are in fact deemed permissible. That's why states repackage activities that were, for example, previously labeled as torture as something else, okay, so that you can maintain a normative position or a rhetorical position of commitment to law while at the same time still doing whatever it is you always wanted to do. So you have, on the one hand, this rhetorical commitment to law, but on the other hand, this instrumental approach to law, that law can and should be bent to allow whatever is considered to be necessary, because that which is considered necessary is sort of considered to be de facto justifiable and thus ought to be lawful. One of the primary examples of engaging with international legal standards in this way, or trying to have them recalibrated, is the engagement by the United Kingdom with some key elements of the European Convention on Human Rights since the attacks of 2001. I think it can be illustrated primarily by reference to two things. The first thing is the United Kingdom's relationship with Article 6, that is the right to a fair trial. So the UK, very soon after the attacks of 9/11, introduced a piece of law, the Anti-Terrorism Crime and Security Act, which allowed perpetual detention. After that, we had control orders. Now we have TPIMs, or temporary prevention terrorism prevention and investigation measures, we will also soon start to use ETPIMs, enhanced terrorism prevention and investigation measures. And in all of these cases, some kind of evidence base is needed for the state to be able to impose the measure in question on a particular suspect. But the state has long asserted that there would be a danger in actually revealing the case against the person to the suspected terrorist. In other words, you would put sources in jeopardy, for example, you would jeopardize security more generally. And so originally this process was proposed whereby special advocates, which as some of you may know actually has its origins here in Canada, I think in immigration law, were to be used, who would originally at least see the case against the person who was called their client. But once they had seen the material, a traditional client-lawyer relationship could no longer exist because they couldn't consult with their client about the content of the evidence they had seen. And this was supposed to be an adjustment to fair trial rights that would keep us in line with Article 6 of the Convention, but also safe from the dangers of revealing the case to the suspected terrorist. Now, the European Court of Human Rights really didn't, to be fair to it, didn't quite go for that. But so effective was the assault on this core principle that you must know the case against you in order to mount a defense to it, that the European Court of Human Rights was convinced to say that gisting is compatible with Article 6. Gisting sounds like some kind of odd dance that people would do at a wedding, but it is actually a process of telling the suspected terrorist the gist of the case against them, and then they can engage with their lawyer, the advocate, and try to respond to it. So this halfway house, which in fact is a fundamental rupture of our concept of equality of arms, is now compatible with Article 6. So through this litigation strategy, the United Kingdom has managed to, what my colleagues Fenwick and Philipson have called, recalibrate downwards the content of Article 6. In relation to Article 3, the right to be free from torture, inhuman and degrading treatment, well, this was a target of the UK right from the start. But to be fair, not all of it. What the UK, and at the time the Prime Minister Tony Blair, was concerned with in 2001 was the standard laid down in a case called Chahal. And this was a case in which the court had held that you could not deport a person to a place where there was a real risk that they might be subjected to behaviours that would otherwise violate Article 3. In other words, if you had done it yourself, would violate Article 3, no matter what kind of a risk this person might be said to pose from a security perspective. Now, very early on, after the attacks in 2001, Blair claimed that Chahal was no longer appropriate for the context in which we were living, that it should be possible to have a balancing act around deportation. Because for reasons that I have to admit completely escape me, the United Kingdom is utterly committed to deporting or removing people from the UK and then letting them presumably do whatever kind of terroristic activity they want as a core part of their counter-terrorist strategy. Now, the UK tried to have the Chahal standard recalibrated through its intervention in a case called Saadi against Italy. And in that case, the UK argued that if somebody posed a particularly dangerous threat or a risk to society, a state should be permitted to take that into account when weighing up the risk that was posed to them in the country to which they wanted to send the prospective deportee. The court didn't buy that. It reiterated in its entirety the Chahal principle, but at the same time, in the saga of litigation around what is known as a radical cleric, Abu Qatada, who the UK wanted removed for trial to Jordan, the European Court of Human Rights and the United Kingdom between them managed, I think, to come to a position where Article 3 and Article 6, the fair trial right, could be in a way made vulnerable possibly even corrupted through the use of diplomatic assurances and some adjustments to trial procedures in the case in question in Jordan in order to have a trial that would pass as fair so that he could be deported. Here this was about whether or not torture evidence would be levied against Abu Qatada. That precedent is actually a little bit ambiguous in terms of whether it's something we should think is a positive or a negative, so I'll come back to it in a little while. But those cases, I think, illustrate this second realm of transnational counterterrorism, and that is engagement with transnational processes to try to change or recalibrate pre-existing legal standards at the international or regional level in order to grease the wheels for desired counter-terrorist activities, as that states can remain compliant with law, at least on paper. The third context I wanted to talk about then is what I've called the business of counter-terrorism. Really, we could talk about this for quite a long time, but I just want to touch on three aspects of everyday counter-terrorism that have transnational contexts or characters of particular interest. The first of these we have already touched on, and that is capacity building. So I've already mentioned the role of the Counter-Terrorism Committee in capacity building around lawmaking. It has also roles in bringing security professionals together in order to share their knowledge in working groups and peer review groups and so on, and case study groups in order to learn from one another. And it is not unique in that. In fact, providing these kind of fora is an activity undertaken by, I think, probably all of the international institutions that see themselves as having any kind of security mandate. The EU, the NATO, OSCE, even the Council of Europe, for example. So I don't want to think too much about those formal international institutions right now because I've already mentioned them. But one of the things that is particularly interesting in the context of counterterrorism and capacity building is the emergence of regulatory sprawl. In other words, the emergence of new institutions or bodies or entities that seem to have support from a number of states or a number of international institutions, but the solidity of their actual foundation is not entirely clear. Where do they come from? Who funds them? What do they do? Why do they do it, for example? So we have lots of these sorts of institutions and bodies emerging. They're regional, they're national. In the United States in particular, they also exist on a state level as well as a federal level. And one of them that is particularly interesting to me is the Global Counterterrorism Forum. This was founded, and it's just an example, this was founded in 2011, and its mission, if you'll allow me to read it, is to reduce the vulnerability of people everywhere to terrorism by effectively preventing, combating, and prosecuting terrorist acts and countering incitement and recruitment by providing opportunities for parties to meet and share capacity and experiences, by supporting the implementation of the UN's Global Counterterrorism Strategy, and by acting as a forum for experts to meet. This all sounds terribly reasonable. Of course, it is terribly reasonable. But what does it mean? What is this forum? Who's in charge of it? What are the standards by which it actually operates? As with any other context in which transnational regulation takes place, these questions hang in the air in a way that it is sometimes quite difficult to resolve. Some things might suggest, though, that the Global Counterterrorism Forum is one of these hybrid regulatory structures that has a particular weight among states. It had 30 founding members, and these included, or these were, I should say, Algeria, Australia, Canada, China, Colombia, Denmark, Egypt, the European Union, the US, France, the UK, so on. So there were 30 states, and then it also has a number of partners. Now, I cannot figure out what a partner is or what it means to be a partner in this context, but the partners include most of the UN's counterterrorism institutions, the African Union, APEC, ASEAN, the Council of Europe, ECOWAS, Interpol, the ICAO, the OSCE, the OAS, sorry for the acronym, for the alphabet soup. In other words, effectively all of the major international institutions are partners to this global counterterrorism forum. And between the members and the partners, the vast majority of the member states of the United Nations in fact fall in some way into the global counterterrorism forum. And what it does, it seems, is to have and hold working groups on particular priority areas. To identify priority areas, at the moment, as you can imagine, foreign terrorist fighters is a priority area, for example. Everybody is terribly worried about this. But it also promulgates memoranda, working protocols, plans of action that are then disseminated among its members and presumably also its partners with an undefined weight. Do we have to follow them? Can we follow them if we wish? And so on. So this forum for capacity building is also, in a way, a forum for transnational lawmaking, for transnational cooperation between intelligence services, for sharing knowledge, for creating harmony in approaches and processes in counterterrorism. And as I said, it's just one example. States themselves will also engage in capacity building. So for the sake of some local colour, in 2004, Canada's new national security policy included a commitment to create the counterterrorism capacity building program, which is funded through the foreign affairs limb of the government. And again, as is the case with most capacity building programs in counterterrorism, recognises that capacity building is important because terrorism creates a security risk in one place that in fact becomes a systemic risk on a global level for lots of different reasons. As well as building capacity, there are also high levels of operational cooperation and coordination between member states. Now, I won't particularly talk about intelligence cooperation because that long predates 2001. For example, the Five Eyes Agreement, which Canada is part of, has existed since the Second World War or thereabouts. But what has changed since 2001 is that where previously we cooperated and coordinated between states because we had relationships of trust, because we were friends, because we knew how each other operated, we now have legal obligations to enhance cooperation with all other states. And those obligations to cooperate and enhance cooperation reside in things like Resolution 1373 from the UN Security Council, where states are required to afford one another the greatest measure of assistance in criminal investigations around terrorism, for example, and in Article 3 to exchange information, cooperate, including through the conclusion of agreements, and so on. So it's actually quite a long obligation, or in fact in that resolution it's not, they don't use the word decides there, they use the words call upon. We call upon states, so strongly encouraged to cooperate in this way. And again, Resolution 2178, the Foreign Terrorist Fighters Resolution from the end of last summer, includes cooperation obligations in the context of border control, and particularly passenger name record data, which I'm going to come back to in a couple of minutes' time. The third aspect of the business of counterterrorism that I want to mention is the extent to which counterterrorism now harnesses transnational private power in order to undertake both investigation and intelligence gathering, but also the execution of particular measures and particular operations. In other words, states are using private power through various different forms of privatization in counter-terrorism. And I've previously written about this as existing across 4 different contexts. You have open privatization or contracting out. Okay? It's actually pretty straightforward. You contract things out, like the development of drones, for example. That is open privatization. There is a tender, there's a process, there's a contract, straightforward. Not unproblematic, but straightforward. But you also, in a more problematic way, have closed privatization. And that is where there is a contracting out that is not public. It might not be known about. So you have secret contracting. And we know that this has happened in the context, for example, of extraordinary rendition, where things like aviation logistics and the provision of airplanes and the creation of flight paths were contracted out. But the existence of those contracts are neither confirmed nor denied by the government. In other words, if you try to get a discovery order against one of those companies, which was attempted in the case of Mohammed against Jeppesen Data Plan, the government will use a state secrets defense, and the court will not be able to have the contracts confirmed or discovered. So we know it happens. We don't know how much of it there is or where it happens or who has those contracts. The third form of harnessing private capacity transnationally actually largely happens at the domestic, though not exclusively, at the domestic legislative level, and that is statutory privatization. So a piece of law is passed which effectively makes engaging in counterterrorism a prerequisite of engaging in commerce. There was an attempt here, as some of you will remember, to have telecommunications companies do data retention, I think a couple of years ago, to have something put in telephones, I believe. Well, data retention is a great example of statutory privatization, where you introduce a piece of law that requires your telecommunications companies to hold certain types of data, which can then be metadata, which can then be accessed by states in cases of serious crime or suspected serious crime, and can also often be shared with other states once they have been accessed by the host state. I said that primarily happens on a national level. Some of you may know that at the EU level, the Data Retention Directive, introduced in the mid-2000s, struck down last April, created this obligation for all telecommunications companies working in the EU. And you had very variable standards across the member states. The fourth type of harnessing of private transnational capacity then is a sort of a fuzzier type, but one that's very worrying. And that is what I call non-contractual cooption. So this occurs where the state, without any kind of firm contract, without any kind of clear parameters, leans on or uses knowledge, capacity, commercial enterprise of private power in order to undertake counterterrorism. So this can happen by getting mandatory orders from courts, for example, that require business records to be handed over, which allow for or enhance some kind of counter-terrorist activity by the state. If you think about the notorious NSA letters in the United States would be an example, or the FISA court warrants against telecommunications providers. The second is where you have an even more informal process of the state effectively asking private power to do something that will help it. A good example is in internet governance. We are now going in the United Kingdom to have a little button on lots of websites, for example, where you can report for terrorism, report for extremism. This is not by law, this is by agreement. I have a bad habit of searching for the word Semtex on Google everywhere I go. Semtex is an explosive, it's bad. But the results will vary depending on the state. Why? Because different states have made different formal and informal agreements with ISPs to superweight or not show particular results on their results pages. So for example, if I search for Semtex in Dublin, I get an awful lot of stuff about Northern Ireland. If I search for Semtex in Durham, I get something about a nutritional supplement, which is apparently called Semtex. So these are, this seems innocuous, but these are forms of harnessing transnational power that are important. Also, things being removed from the internet on the request of the state without a warrant. It's also very common. And thirdly here, you have the simple use by the state of open source information for both sentiment analysis and sentiment manipulation. In other words, states simply looking, monitoring traffic, chatter on the internet, Twitter, Facebook, etc. They're just looking effectively, but they also sometimes will engage in some manipulation by having particular messages put out, and there is a high level of development of sentiment analysis that is trying to figure out risk level, or help to figure out risk levels through internet chatter. That's through open source, regular websites. So after that whistle-stop tour of these three different kind of, I suppose, categories or loci of transnational counterterrorism, we come, I guess, to the question of why we should worry about that at all. And I promise to not take too much longer. We might ask why we ought to worry, because on the one hand, it will seem to us that these things that I've been talking about, sharing intelligence and looking at what's happening on the internet and making sure that we have an obligation on every state to criminalize things that we think are dangerous from a security perspective, that all of these things actually might be quite sensible. Why wouldn't we do that? It will make us safer. It will make counterterrorism more effective. And perhaps in some ways it will. But as I mentioned at the start of the talk, there are some particular things about transnationalism here that ought to be causes for concern if we care about constitutionalism and human rights. And I take it for granted that all of the normal risks of setting up a security versus liberty dichotomy that exists at the domestic level act as a meta-narrative to these particular concerns as well. So those concerns of seeing rights and security as opposing rather than interdependent values also exist. The first reason to worry, in my view, is that we have the development of security measures and the engagement with security operations taking place on a transnational level in which there is an underdeveloped constitutionalism. In other words, you have bodies that do not themselves have necessarily clear, well-integrated constitutionalist values engaging in the process of making law, justing law, undertaking counterterrorism without that constitutionalist grounding. The Security Council is a great example. The Security Council has 15 member states, 5 of which are permanent. It is not transparent, it's not participatory, it's not open, it's not democratic, and it can make law effectively for every member state of the United Nations through resolutions such as 1373. In addition to those sort of core constitutionalist concerns, there are also within international institutions often, although not always, disjunctures between their apparatus for security and their apparatus for rights. The United Nations, of course, has an excellent apparatus for the protection of human, or at least for the promulgation of standards supposed to protect human rights. But that apparatus and the security apparatus, which resides primarily within the Security Council, can hardly get to communicate with one another because one has no true obligation to take into account the view of the other. And so, and in that case, I mean the security apparatus has no clear or enforceable obligation to take into account the views of the rights apparatus. Now, that's not always the case in international institutions. The European Union, for example, does have a more developed constitutionalist character or constitutionalism, as illustrated by well-known cases like the Cadi case, which required the Union to go back and revisit its implementation of sanctions provisions emanating from the Security Council, or the recent case striking down the Data Retention Directive. But even then, the institution is imperfect. It was only with the Lisbon Treaty, for example, that the European Parliament got any real capacity to engage in the process of even debating the European Union's approach to counterterrorism domestically, so as domestically there being within the Union, as opposed to as a matter of common foreign and security policy. And even where constitutionalism seems to be building up to create some kind of fusion between rights and security apparatus, the capacity for regulatory sprawl, in other words, for simply engaging with some other institution that doesn't have that kind of constitutionalist foundation yet or at all exists, so that we go outside of, or can go outside of the constitutionalist context to something less protective of rights, to undertake the everyday business of counterterrorism in particular. A second concern is that by mandating cooperation between states and by engaging in counterterrorism as a transnational enterprise, we are necessarily reliant on states that do not have that may not have the same kinds of constitutionalist infrastructures or commitments that the states we might otherwise or normally have engaged with would have. In other words, that movement from cooperating with our friends to cooperating with everyone. So we don't know where intelligence comes from. We don't know what will happen with the intelligence that we might share with our partners. We don't know how reliable it is. And this is a concern from both a security perspective and a rights perspective. By the way, if I don't know what's going to happen to the intelligence I give you, then that creates a risk for me that you might give it to the person whose activities I'm trying to disrupt. I mentioned that the Abu Qatada case is an ambiguous one, and that is because Jordan, in the end, changed its domestic law to make the criminal justice system look more like an Article 6 compliant system. And he was then, well, in fact, he went voluntarily. He then went to trial and was acquitted in Jordan. And this brings the argument that people sometimes make that through this cooperation, in fact, you can build rule of law and constitutionalism in other states. However, that argument is completely reliant in many ways on the value that the partner state holds for you. A partner state who can do most for me to enhance my security is the partner state that I am likely to make the least demands of in terms of constitutionalism, or at least the least conditional demands. And of course, a hanging question here is whether or not creating obligations to criminalize in fact creates the opportunity for some states to impose politically motivated laws in a corrupt manner against those who legitimately oppose an oppressive regime. A core concern, of course, is the undermining of democracy and deliberation. I've already touched on this. The passenger name records example is a good one. There have been attempts at the European Union level to have passenger name record data exchanged between member states for years. And civil society, the European Parliament, the LIBE Committee, all the sort of rights-oriented entities you can think of have expressed serious concern about this. And they had never managed to get enough momentum behind it to introduce a PNR exchange system. But now they don't need the momentum because they have a legal obligation under UN Security Council Resolution 2178 to exchange passenger name record data, which would seem to completely undercut the deliberative democratic process across member states, not just in Europe, of course, but more generally. Now, you have held on for 45 minutes for the optimism, so here it comes. So, I think the cameraman is going to kill me. Sorry, I keep moving around. So let's think about these challenges that transnationalism pose. As I said earlier, I'm not going to propose a model per se of responding to those challenges, but I want to propose that there are 4 principles or 4 commitments that we need to bear in mind if we are to respond to the challenges of transnational counterterrorism from a constitutionalist perspective. The first is that imagination is imperative. There is a tendency in political science and in legal scholarship to try to model processes of transnational constitutionalism and rights protection on what we have at the domestic level. In other words, to say, well, we could effectively have some separated powers, we could have some checks and balances, and so on. That is a perfectly noble enterprise, but on its own, it is not sufficient. A domestic model of constitutionalism and rights protection does not translate to an international or transnational reality. And this is why we must, as my second point, be realistic about realism. States do not trust one another. States will not make themselves voluntarily subject to any system of intelligence or security supervision that might be effective. States that are powerful will not voluntarily give themselves up to a system that limits their capacity to be hegemonic. It would make no sense for them to do so. Thus, we have to try to create systems of security oversight and intelligence oversight that take the reality of realism into account. This means to some extent that we have to recognize, as my third point, the limits of law. This is, of course, an almost heretical thing to say, right? When you're a lawyer, everything can be fixed with law, except it can't. A lot of this has very little to do with law. And in a lot of counterterrorism, you can have all the law in the world that you want. You can have the best looking international constitution that you want. But unless there is an ethic of constitutionalism among states, and that is enforced by peer pressure among states, those legal standards and legal structures cannot be effective. And so we need to be imaginative, to think about things like transparency initiatives as mechanisms of constitutionalism, leaking, to think about protest, to think about lots of non-legal mechanisms, including trying to put some pressure on private companies that we know engage with security apparatus, for example. And finally, for me, we have to recognize the enduring importance of the state. Transnationalism is in some ways an escape route for states from national constitutionalism. But national constitutionalism, courts, political accountability, elections, the media, these are the ways that states are most effectively made accountable for what they do. And they are the ways that rights and constitutionalism as core values are most effectively safeguarded, particularly in the context of security. This is not to say that the state is perfect. Courts are deferential, parliaments give in to panic, people don't care if there's no oppressive law that is not imposed on them, as long as they feel like it's keeping them safe. Of course, we must be realistic about realism at the domestic level as well. But any suggestion that we live in a post-national state in which constitutionalism can and will operate without strong constitutionalist states plays into the hands of states who do not trust each other, will not submit themselves to effective international or transnational supervision, and will continue to pursue security through transnational mechanisms. Thank you.